We are live.
Good morning. This is Senate Judiciary. A beautiful day outside, but we're here in this committee room taking up H89 first, which is has to do with legally protected healthcare activity. And Michelle Childs is going to walk through several amendments with the committee, and then we would take comments from anybody in the audience or on Zoom. Michelle, if you could walk through them.
Sure. Good morning. For the record, Michelle Childs, Office of Legislative Counsel, and we are taking a look at draft 1.1 of a committee amendment to H89. There's two instances of amendment. The first one being replacing the definitions in H89 in section 1 with the definitions that are in S37 that passed. And I'd explained a little earlier is that H89 was moving faster in the House than S37, and we were using the same definitions and need to keep those the same, even though the bills deal with different issues, but they're related. And so this is just employing the S37 definitions. House Healthcare is working on S37 currently, and they're making one small tweak to the definitions that the Senate passed in S37, and that is just to clarify that in the definitions of gender affirming healthcare and reproductive healthcare, that medications related to that care are included there. And so I'll just walk you through the language here. So if you look at the first page in the first instance of amendment, you have your definition of gender affirming care services. Again, as I mentioned, this is already something that the Senate passed. There's just the addition of the words on line 12 that says including medication. Subsection B, again, this is the definition of legally protected healthcare that the Senate passed. And so we're just putting it into this bill. If just kind of going over it because it really is the heart of the bill. And if we go through kind of section by section of H89, if you want to do that this morning, it'll be good for us to have a refresher on the definition. So subdivision B1A, that is pretty clear just about that legally protected healthcare means the exercise and enjoyment of any person's right to reproductive healthcare service or gender affirming healthcare services.
What line are you on?
19 and 20.
So I'm on legally.
Page 1, 19.
Page 1.
Okay, you said B1 and I don't see B1.
So page line 15, subdivision B1, yep. And then I'm on A.
Okay.
And again, so we're not changing the standard of care. We're not changing anything around consent. Minors still need to, there has to be parental consent and involvement in gender affirming care. So we're not changing anything in terms of access to care here. We're just protecting it from outside litigation. Subdivision B1B, starting on line 19, that applies to folks who are assisting in the provision of someone obtaining that legally protected health care. And then I'll just note, because it's key in a few different sections in this bill, is that healthcare is protected. And you see at the top of the page, provided that the provision of the healthcare service by a person duly licensed in Vermont, so the person has to be, who's providing the service has to be licensed here, and the person is physically present in the state, so that provider would have to be located here, shall be legally protected if the service is permitted in Vermont, regardless of the patient's location. And so that's one thing that is different from the standard, which is typically the healthcare is considered to be provided wherever the patient is located. But this says for purposes of these two types of care, that it is protected as long as the provider is licensed here. And the provider is physically present here. So this would be in a case like and there's another provision down here that talks about telemedicine. And so this would be if you have, Vermonter and they have their provider here and they receive services here, but maybe they're on vacation and they're traveling and they're in Idaho and they need to reach out to their provider, say, my medication is, I'm having headaches. Could this be related to my medication or something like that? Is that provider who has the relationship with the patient would still be protected, even though the patient was elsewhere at the time.
While we're on that topic, we're talking about telehealth, right? Or
Yes.
Yeah. So I believe there was a current concern brought up about a doctor or a provider of any sort located in Vermont, licensed in Vermont, providing medical guidance or prescriptions to somebody who's out of state, and then concerns about the licensure if they're providing guidance to somebody who's in a different state. Can you talk about how that would work?
S37 deals with licensure, and so but I do know a little bit about it. This is not authorizing someone to practice without a license in another jurisdiction.
Yeah.
And that other state can follow their own laws, and they can either reprimand someone or do whatever they decide to do in that other jurisdiction if they decide to proceed against someone if they're not properly licensed in that other state to be providing that. But what this bill says is that as long as the provider is licensed here and physically present here, so it wouldn't cover if the person is licensed here and then goes to the other state and provides that without a license.
That bothers me. And I can just give you an example. My wife's neurologist is in Pittsfield, Mass, which is, not far from Bennington. During the pandemic, we used telehealth for him to talk to my wife, situations and so forth. My question, I guess, is if he wanted to provide services to somebody. Again, he's a neurologist, so he probably wouldn't be involved, but what if the physician, he's licensed in Vermont and Massachusetts, so why couldn't he be in Massachusetts and provide that help to that woman?
You lost me there at that last little bit.
Why
So if
couldn't he
he's
provide, let's say.
if he's licensed in Mass.
He's licensed in Mass, licensed in Vermont, but he's not physically in Vermont.
Right.
Why couldn't he provide services to that woman who, obviously they probably wouldn't need a neurologist, but you got to,
I get what you're saying. Well, if he's licensed in another state, he just can't violate their laws if there's certain things that are prohibited, such as gender affirming care
but the patient is physically in Vermont. He's physically in Massachusetts, which I'm assuming has similar laws. The physically present is where I'm at. Why do you have to?
Are you following what he's saying? I'm sorry.
Chesapeake Vermont Medical Society, if I can address the broader telehealth context separate from gender, regardless of the type of care being provided. Vermont actually has taken a look at this in the legislature last year, I think it is, passed ongoing licensure flexibilities for telehealth care, so that neurologists located in Massachusetts and if they are licensed in Vermont, actually can provide ongoing telehealth care to somebody located in Vermont. That's no barrier. If you're not fully licensed in Vermont, there actually are going to be pathways for telehealth registration and telehealth licensure. Actually, there are already under COVID flexibilities, and then there are going to be permanent ones.
But when we use the language physically present, let's say it's an obstetrician at the Berkshire Medical Center, and the person is from Pownell. That's in North Adams.
Right.
They're closer to North Adams than they are to Bennington for a doctor, let's say. And I'm saying,
I think it's the issue of what Vermont can dictate to another state.
Right. I mean, we can't control what Massachusetts
so,
does.
but again, I'll say I'm concerned with the physically present. The doctor has to be physically present in Vermont.
It's the,
The woman needs the pill,
mhm.
which is, under the, and can that doctor from the Berkshire Medical, the obstetrician, can he prescribe that pill to that woman? He's not present in Vermont. She might even do it by phone call.
And is it a Vermont provider or it's a
It's
Massachusetts
a
provider?
Massachusetts provider that's licensed in Vermont. We have a lot of them, actually. We have, actually, the guy that does, my heart doctor is licensed in New York. He does procedures in Albany because they have better equipment there. So, this, particularly in, you have Dartmouth Medical Center, which is in New Hampshire. I'm just concerned that a lot of people use out-of-state doctors.
I don't think that that's something that we've discussed before in the context of this, in terms of we were trying to shield Vermont providers.
Understood.
And
But
I think,
Vermonters use providers from other states.
right.
And I think we should, it bothers me that, that probably the same thing's true in Brattleboro.
Jessica Varner, Vermont Medical Society, the conversation did come up with a couple of stakeholders after the bill passed the House in terms of, well, what if it's a Vermont provider even traveling? And they are Vermont licensed, they normally work in Vermont, but they're on vacation in South Carolina that week providing telehealth services. I think we just, at that point, a few of us who were discussing this thought it just gets a whole other level complicated of then what legal protections we can provide that provider if they were out of state at the time of the services. But I understand your question, and there may be ways to frame it that it applies to somebody licensed in Vermont, regardless of where they're located when they're providing the services. I just think that would probably require a whole other analysis of what, then they return to Vermont, I think it just gets more complicated.
Because the physically presence, just to add on with centers, does that mean they have to reside in Vermont, or just like you say, they could just come from Massachusetts up here, be physically present and then perform whatever that's what that
Right.
means?
So the idea is that, it's not going as far as saying that if you have a Vermont provider who then goes physically to Texas and performs abortions in Texas in violation of Texas law, that would not be protected under this. And and like I said, it's carving out an exception right now, saying that the patient can be there. Usually it's that the service is considered to be rendered wherever the patient's location is.
So they don't have to be a resident, the provider of Vermont.
No, they would have to be licensed here.
They just have to be licensed here.
They're physically here when, okay.
I just wanted to loop back to my original question real quick. I just want to make sure I fully understand the answer. So if a licensed doctor in Vermont wants to provide telehealth services to, let's say, a Vermont student that's gone to some hypothetical state, the student calls the doctor on Zoom or whatever process it is, but there are rules in that hypothetical state that say, under no circumstances can telehealth services be provided from providers out of state. Would the Vermont doctor then have to say, I'm sorry, but I can't help you because of the rules in that state?
That would be a decision to be made by that particular physician, and they would have to make a choice about whether or not they were willing to assume any risk that might be incurred by Texas, like that Texas would take action against them. Vermont would not take action against them.
Gotcha.
But Texas, we can't control what Texas does.
Right.
And so, but there are provisions in here that say that if Texas were then to go after that physician, that Vermont would not cooperate with that investigation.
Okay.
Well, I'll drop my physically present concern, but.
We'll think
I'm
about it and
really-
see
I'm
whether
really
you can.
Concerned about it. I'd like to have it looked into, since so many of, you know, I'm thinking of Scott Rogie, who's a heart surgeon doctor. You know, when I was in Albany, they're all the doctors from the heart unit at Albany Medical Center asking how Scott's doing, you know? They all know him because he comes over there and does procedures. And so he has a patients in New York, other doctor, Dr. Cloman, has neurologist has patients in Vermont, but he's physically located in Massachusetts. And I'm sure when you look at Dartmouth Hitchcock, which is where many of the Southwest Vermont Medical Center doctors are, they're not located in Dartmouth Hitchcock. They're physically in Vermont because they're at Southern Vermont Medical Center, but they work for Dartmouth Hitchcock. So that, I mean, they have that relationship. So you have, that's in New Hampshire, technically. You know, it doesn't kind of Chittenden centric. We're on an amendment to H89, and I've been making a plea on the top of page 2, line 3, which requires the doctor to be physically present in the state. Because many of our doctors, at least in Bennington County, have licenses in Massachusetts or New York, and maybe in the offices in Massachusetts on the day that the woman needs a pill and needs to have be prescribed, but under this, that doctor who's licensed in Vermont couldn't prescribe the pill or provide any. Maybe he wants to see her and says, I'm in North Adams, you're in Pownell, not a very long drive, come on down. And you know, I just think physically present is what I would like to strike, but we're discussing whether that's possible.
So I will just note that this, something that somewhat related to this is that on your extradition section in the underlying bill, the Vermont has chosen generally, as long as an extradition warrant is validly executed in the demanding state, for someone who is a fugitive from justice, you have to comply with extradition order. However, the exception that you have in here where Vermont can make a policy choice around that is around if the person who the demanding state is looking to have extradited was not physically present in the demanding state at the time of the offense. And that's where, because what the extradition clause of the US Constitution requires is for extradition if someone commits an offense and then flees jurisdiction. And so that's another place where the issue of physically present comes up.
I was gonna ask if that physically present has to do with personal jurisdiction, and on hearing the extradition piece, I'm feeling like that might make sense then. So.
We're on page 2, Senator Brewer.
Okay.
On line 3, we've agreed pretty much with the amendment, except we're discussing the physically present piece. That if the doctor's license in Vermont is in Massachusetts that day at the Berkshire Medical Center, and his patient needs a pill and needs it prescribed, can he do that in Massachusetts, but he's licensed in Vermont, it's a Vermont patient? Would he? And this, by physically present, that would not allow that. And I was pointing out, we have a number, doctors who work in New York, work in Vermont, Vermont, all of the doctors, not all, but many of the doctors at Southwest Vermont Medical Center in Bennington work for the Dartmouth Hitchcock. And so many of those doctors go between Dartmouth and Bennington.
I think to this point, one of the issues is that perhaps the reason for the physical requirement of being in Vermont is, if they're in Massachusetts, the doctor, and they're performing the act of prescribing the pill or providing whatever services they provide, how can Vermont extend its protections included in here into Massachusetts, which is where the act is happening? So I'm understanding now why the physically present is outlined like that.
Probably
is
can,
included
but
like
I
that.
think it leads to problems if Massachusetts or New Hampshire or New York were to pass strict abortion laws, like some of the southern states.
Right, but I think Nader has hit on it, which is that you need to have a certain number of minimum contacts in order to have personal jurisdiction in this particular situation. So if
I'm
you
willing to let it go at this point, but it could present problems.
Well, if all those states pass these kind of restrictive laws, we're in all kinds of trouble.
Yeah, if Massachusetts is doing that. Then.
I mean, if you took out the requirement around physically present and you just had that it was somebody who is licensed in Vermont, then you could arguably have a Texas physician performing abortions in violation of their state law. But if they have a license in Vermont,
Yeah.
That wouldn't work.
and then this would say, well, you're protected in Vermont, and so it's
Right.
not.
Yeah, I'm understanding the concerns that are being raised by Senator Sears, but I think that looking at the personal jurisdiction piece of it as it relates to minimum contacts, as you were talking about, I think I understand now why the physical requirement is included in there. So I'm
willing to move on, but I want to raise that issue and maybe look at it if it arises, if it becomes a problem, or a woman trying to receive, or a transgender, gender affirming care, or an abortion, or any pill or whatever.
All right, so next provision is subdivision C. I'm going to skip over that. That has to do with the provision of insurance, which is dealt with in S37, but we're using the same definitions. Subdivision 2, starting on line 14. This is language, and you'll see language similar to this in a number of places in the bill, which just states that if something is actionable here in Vermont, then it's not going to receive this shield protection. So in the case of let's say someone receives care, but it's substandard care in violation of best practices, and they are harmed, this means that it's not going to prevent them from having a med-mal suit against the physician in those circumstances. Subdivision 3 at the bottom of the page. This is the provision around telemedicine and kind of goes to what we were just talking about, which is that if the service is provided by someone who's licensed here and is physically present here, then it's protected if the service is permitted here in Vermont, regardless of the patient's location or whether or not the healthcare provider is licensed in the state where the patient is located at the time the service is rendered. So this is not an authorization for Vermont providers to be practicing without a license in other jurisdictions. But it just is going to address those situations that we were talking about where you have a Vermont provider and maybe their patient is traveling or going to college somewhere and they need to have a telemedicine appointment with that provider. Hopefully that provider would be licensed in that state, but if they're not, we're still going to protect it on our end. Again, that other state can do whatever it's going to do, but we're not going to assist in any type of criminal or legal sanctions against that provider in that other jurisdiction. And then subsection C, this is just the definition that the Senate passed in S37 for reproductive health care services, with the addition of the new language on line 8, which it says including medication. And then the second instance of amendment is changing the effective date for the entire bill to be on passage. You'll recall that the testimony from Lauren Hibbert yesterday was that she thought she could do it quickly and did not need the extended date bumped out for that.
Okay.
So would you like to go through 89 and go through all the other sections as in order
We've
to
been
just,
through them?
you have, I just wasn't sure if you wanted to for a final discussion or if you just want to chat and have questions. I know
I don't,
Senator Hashim mentioned
I
full faith and
wanted
credit.
to give an opportunity if there's anybody that wants to speak online or. I'm Senator Hashim.
I do have a question, not about full faith and credit, but Article 22, there is, as accurately as I can remember, there is some concern about parts of this bill being in conflict with Article 22. Is anything in this bill, from your perspective, conflict with Article 22?
Not in my opinion. I mean,
Okay.
the Article 22 is a protection against government interference with bodily autonomy, reproductive autonomy, and reproductive liberty. I would need to understand a little more about why.
I believe, give me one second. I believe it has to do with conversion therapy because it's not covered. Yeah, gender affirming healthcare services does not include conversion therapy in section 1, is what I'm seeing.
So the assertion would be that by the state having previously banned conversion therapy, that the ban on conversion therapy on minors is a violation of Article 22?
Yeah, do you see that as accurate or?
Well, it's law now.
Right, so I have to read a little more about conversion therapy, but I'm trying to understand the connection between conversion therapy and reproductive liberty.
Mhm. Yeah.
I don't understand the thread between those two.
I'm just I'm just asking the question that I've seen a few times and just wanted to see if you had any perspective on it. But if you're not seeing a connection, then I defer to your judgment.
No, this is the first time I've heard of that.
Yeah, I myself, I can't believe it's a problem, but the fact that conversion therapy is singled out for some small group of constituents might be an issue, that they would take issue with the ban on conversion therapy.
Right, I think that's not so much around this.
Yeah,
I mean, if their argument is that our existing ban that existed prior to the passage of Article 22 is now, in violation of constitutional protections, and that would be incumbent upon them to challenge the conversion therapy, not this.
Yeah.
it is a tough connection to make though, because
Well, I think this is something that, is it clear? And is legislative intent clear? Because it's something that may end up with the Supreme Court making a decision. And as long as I'm comfortable, as long as you believe our intent is clear in.
I don't think this changes anything with regard to this argument that conversion therapy
Well, yeah,
is
but
an
the
infringement.
argument will end up in the Supreme Court, not with the legislature.
well, it's clear,
Right,
clear
but-
in the bill that conversion therapy is not covered.
Is not covered.
So our
It's
intent-
not legally protected, but right now that's because it's banned under current law.
I understand, and that's why I'm saying that if somebody wants to challenge that ban or challenge this bill, it would end up with the court. And as long as we are clear on why we're doing it, what the legislative intent is, I think we're okay with the court.
I personally don't have any concerns about that.
I think that was really the question.
Yeah, I mean, I think this wouldn't give somebody additional weight in court that they wouldn't have
No,
just challenging the.
Right, that's what I'm saying is I think it's a separate issue. And then, it would be up to whoever wanted to challenge that to, challenge it. And then the state could come and say, here's our compelling reasons for banning this type of practice. And, so it's the article, it's not, obviously things can run afoul, but it's a strict scrutiny standard. So it's a higher standard. And then it would be up for the Attorney General's office to defend the conversion therapy ban as to why it should survive strict scrutiny.
Thank you.
Are you ready to vote? To approve the amendment first? Is there a motion to amend H 89 as seen in draft 1.1? Yes, Senator Baruch has moved that we report favor that we amend H 89 as seen in draft 1.1. Peggy, would you please call the roll?
Senator Baruch,
Yes.
Senator Norris,
This is on the amendment?
Yeah.
Yes.
Senator Bihowski. Yes. Senator Hashim.
Yes.
Senator Sears.
Yes. Now I entertain a motion to report favorably H 89 as amended.
Make that motion.
Senator Hashim has moved that we report H 89 favorably as amended. Is there any further discussion on this bill? Hearing none, Peggy, could you please call the roll?
Senator Baruch,
Yes.
Senator Norris,
No.
Senator Bihowski. Yes. Senator Hashim.
Yes.
Senator Sears.
Yes. I'd like to report this. We have 4 choices.
Seems like a nod or two.
I think Nodders.
That's, oh, sure. Yes. Happy to.
Good.
Unless,
Peggy,
unless you.
I need to have this edited. I
Somebody that
thought
votes no
there might
can't
be
report.
I
no.
Just like giving Bob a hard time.
Although
That's
there-
really why he voted no. He didn't want to report it.
there was one time, I remember.
Nor will be on
Francis-
conference.
Did you remember Francis Horrigan? Oh, he's a state senator from, and I remember him on the floor getting questioned about something. And he had evidently voted against that amendment in the bill, and he said, I'm just pushing this wheelbarrow, I didn't fill it.
That's a good line.
I like it.
Senator, you let me know how I can be helpful.
Yes, I'll send you an email.
Okay.
Some conversations that I want to
Happy to
get
do
ready
that.
for. Yeah, thank you.
Okay, and I will send, after I have this edited, send it to Peggy, so we can bring it up.
We're on break until 10:15.
Well, you guys, I feel like y'all are
10:30.
wrapping up early every
Yeah.
time I'm in here.
10:30.
No, but we're, can we get, we'll do our committee discussion starting at, on H 230, starting at 10:15.
Okay.
Okay.
And then we can, at 10:30, we can take up some of the